So as I said, thank you everyone for joining. This is the second of the HR webinar series. It's a collaboration between Club Benchmarking and Paychecks. Our purpose is to provide you with professional HR education that's tailored to the private club experience and hopefully develop a network of private club HR professionals as well as resources for all of you. Mike Wales is a senior consultant for Paychecks, and he is also the coordinator of education for the PIRA chapter of SHRM in the Coachella Valley. And Mike has been really incremental in building out this webinar series. So Mike, thank you for your help in coordinating.
Happy to participate. The clubs are a great organization. And since my daughters both got involved in golf, I so appreciate what the private clubs do for junior golf.
Excellent, thank you. And Mike's a great resource for any of the attendees that are from California as well. He's just a wealth of information. Providing the legal update today, we have attorneys from Hirsch Roberts Weinstein Law Firm in Boston. Their attorneys Kathleen Berney, Mike Derderian, and Pete Moser each have extensive experience with employment and labor law. And we've actually had the pleasure of working with HRW before at the 2018 Boston HR Symposium. So I really appreciate the opportunity to work with everyone again.
Thank you. We're happy to be part of it.
Excellent. Well, so that's, you guys can feel free to introduce yourselves a little bit more and then take it away.
Sure, thanks. We'll jump right in. So this is Pete Moser talking. Hopefully everybody can see at least three of our smiling faces up on the screen. Myself, oh, we just backed it up. I was going to say we have a fourth with us today, Jordana Douglas. So we have four presenters today. And, I wanted to give Jordana credit because her name is not on the marquee as of yet.
Oh, thank you. I'm sorry about that.
It's on us. It's a late edition. Go ahead, one slide there, Aaron, if you would. So this is the agenda we put together. It's actually a pretty packed agenda for a 45-minute, 1-hour program. But this is what we're going to try and cover today. We all, on our end, put some thought to the title, What Employers Can Expect in 2020. We all got our crystal balls out and did some crystal ball gazing, and this is the list of stuff we came up with and we intend to cover today. So tops of the list, the Department of Labor salary changes. Sort of a great get your feet wet thing to expect in 2020. Everybody has probably heard a lot about this. Is familiar with the salary threshold increase that's going to be taking effect January 1st, but you can't do a program of this nature without at least talking about that. So we'll spend a few minutes talking about that, and that'll be Kathleen Berney who will kick us off with that. Next on the list, Title VII, the anti-discrimination statute at the federal level. Again, for the folks on this call who do pay attention to this stuff, I know it. They've heard a lot about this issue as well. There's some pending cases at the Supreme Court that may well expand the definition of what sex means under the anti-discrimination laws, and that's where Jordana Douglas is going to spend a few minutes talking about that and updating us as to what's going on that front. So the crystal ball gazing, I think, is clear up to that point. We know these things are going to be happening, or in the case of the Supreme Court case, not happening at some point in 2020. Now we get into some sort of the trends and things to look out for and landmines and that sort of stuff. One of them is on the equal pay front. That's an area we've seen a lot of activity in recent years, particularly at the state level. So we'll spend a little bit of time talking about that. And I think we all expect that trend to continue. It's a focus, and certainly in an election year will continue to be so. Below that on the list is a bullet that has MeToo/retaliation. Two more trends that we've seen in recent years. Certainly the MeToo raised awareness of sexual harassment, results in increased claims and increased obligations on the employer side. We'll talk about that. Retaliation claims have been on the rise for a while. We'll talk about that too. The next two bullets Mike Derderian is going to cover on wage and hour issues, independent contractor issues. Those are, a big thing for clubs to be aware of, as they are for all employers across all industries. And then, time permitting, we'll end up with some NLRB labor issues. Most folks think labor union issues are a niche issue given the low density rate of unionization in the private sector, but there's lots of stuff going on the labor front that affects non-union workplaces as well. So we'll spend a little bit of time talking about that. So that's the agenda. We're already running late. It's about 10 minutes in, so we got to turn this over to Kathleen, who's going to talk about the Department of Labor salary changes.
Okay, thanks, Pete. So, Department of Labor salary changes. We're going to start with our first polling question of the day, and I'll read it for you to consider. As of today's date, an employee, is it a true or false? As of today's date, an employee with the word superintendent in their title, for example, the superintendent of buildings and grounds, who earns at least a salary of at least $455 per week, is automatically exempt from minimum wage and overtime requirements under the United States Department of Labor Standards Act, the FLSA. True or false? So you can go ahead and choose that on your end. Go ahead. And the answer is false. And the reason that's false is merely because this employee's title is superintendent of buildings and grounds, which may sound exempt, it's not necessarily exempt, and that's because job title alone does not indicate whether in fact someone is or is not exempt. So let's step back a moment. What does it mean to be exempt or non-exempt? Simply put, if you're non-exempt, you're subject to overtime. Your employee is eligible to receive overtime pursuant to the Federal Labor Standards Act. And there's a presumption that an employee really is non-exempt unless they fit into one of any of a number of exemptions. So these are white-collar exemptions. Essentially, the FLSA is saying that these exceptions don't apply to a manual laborer or another blue-collar worker, and there are certain standards or qualifications that must be met. So not the title alone. So, next slide. We've got 3 tests. We'll start with the job duties test, and we're going to use one of these exemptions, the executive exemption, as an example. So, to be considered exempt for overtime under the job duties test for executive exemption, the employee's primary duty must be managing an enterprise or a customarily recognized department or subdivision of an enterprise. This is key. The employee must customarily and regularly direct the work of at least 2 or more full-time employees or their equivalent. And they must have some authority. They must be able to hire and fire, and their suggestions regarding promotion, hiring and firing, and other employee status-related information must be given weight by the employer. So then you've got 2 other components of a test in addition to the job duties, and both of those relate to salary. The one is the salary level. Currently, that level is $455 per week, and the salary basis test means that salary is predetermined. So in other words, if that employee doesn't work a full day, or a full week, you do not dock their pay. Their dollar amount is paid regardless of the number of hours worked in the week, as well as regardless of the quality or lack thereof of that employee's work. So that's what the no improper deductions is getting at. You can't decide as an employer, hey, they didn't do a good job, I'm going to take out X dollars from their salary this week. So all 3 of those are required, and we've got these different exemptions, which some of you I'm sure are familiar with in terms of organizing and auditing your employees and their job titles. And I know that some of these professional employees, those can apply to doctors and to lawyers. Computer employees are their own special class. And the one we see very often in the club context are executive, administrative employees. That's where this will come up a lot for you folks. So moving into the crystal ball component of this topic, let's ask the next question. As of January 1, 2020, the required salary for exemption will A, increase from $455 a week to $684 per week, which is equivalent to 34568 annually. It will B, decrease from 455 per week to 384 per week, or C, it will stay the same. And the answer is A. So you might already know this, as Pete mentioned. This has been coming for a while. This final rule will go into effect on January 1, increasing the salary level to $684 per week. So if you haven't already, if you've got any employees on the cusp in terms of what they're making now versus what they will need to make as of January 1, you'll need to look at that very quickly. We'll also increase the total compensation amount for highly compensated employees from $100 to $107,431 per year. And this is important to note as well, if you are going to be auditing or looking at your employees' pay right now. You can now apply non-discretionary bonuses and incentive payments, including their commissions, to satisfy up to 10% of this new level. So those that fall in that gray area, if that's applicable to them, that might be helpful for you. In addition, a catch-up payment may be something you can pay if the employer hasn't earned enough in non-discretionary bonuses and incentive payments to retain their status. So what are the takeaways for you? I mentioned an audit. You probably want to take a look at your employees' job duties and going in with the mindset that it's best not to assume they're exempt based on the job title or even based on salary alone, and take a look at those salaries, review them, review the salaries, review the job duties, and if you think that you may need to reclassify, you'll need to think about several things, how that may impact employee morale, how that might impact fellow colleagues, how that, of course, while recognizing you do need to be in compliance with the law. In many of these instances, if it's a close call, just on the safe side as lawyers, we generally recommend that you don't treat someone as exempt because, as I mentioned earlier, there is that presumption of non-exempt out of the gate by the DOL. So those are some things for you to think about, and thanks for your time on this topic.
Hey, this is Mike Wales. I'm in California, so just as a reminder to anyone who is in California, California, of course, likes to do everything a little bit better or a little bit worse, depending on your perspective. So know that California is much stricter in this area, and with the minimum wage going up, you have to double the California minimum wage to come up with the exemption on the salary side.
That's great. Yeah, that's definitely a special consideration for California folks. Thanks, Mike. So we're moving on to our next topic on equal pay, and we'll start again with a polling question. This year, players of the United States women's national soccer team sued the United States Soccer Federation, alleging one of the following: A, pregnancy discrimination and a failure to accommodate under Title VII and the American with Disabilities Act, for allegedly failing to accommodate their pregnant players. B, they sued for sexual harassment under Title VII. Or C, the women's soccer team sued for gender discrimination in violation of Title VII and violation of the Federal Equal Pay Act for allegedly paying the women less than the men players. And the answer is C. You might have guessed that, considering that's the topic here that we're speaking about, the Equal Pay Act. So the answer is C, because the women's soccer team, in fact, actually got granted recently class action status for this lawsuit, alleging that they essentially do equal work to the men's team, but they're paid somewhere upwards of 38% less than the men players. So what is the law here? The law on the federal level is the Equal Pay Act of 1963, and I've got the full statute up there for you. And essentially, it's saying that members of the opposite sex who perform equal work on jobs requiring the performance of equal skill, effort, and responsibility performed under similar working conditions must be paid the same, except if they, one of these exceptions are satisfied. And the big one here on the federal level for the Equal Pay Act is that provision 4 is a bit of a catch-all. It provides an employer a differential based on any other factor other than sex. So that can justify, any of a number of reasons why a man and a woman are paid differently. So, along with this, during the Obama era, in an attempt to really put some teeth into the Equal Pay Act, which has been around for a long time but has not necessarily been in the forefront in terms of legislation, in terms of employers needing to abide per se by it, the Obama era instituted a whole new data collection, pay data collection requirement. And this is for you employers with 100 or more employees who you're currently already providing demographic data. And under the Obama era, you were also going to be required to provide W-2 data and hours worked data for your workforce. Now, once Trump took office, they were not very happy with this requirement at all, and they stayed this requirement to provide the pay data. And recently this year, if you are an employer of 100 or more employees, you probably did hear about this stay being lifted, and you are, just for this year only, as an employer of 100 or more employees, required to provide this W-2 and hours worked compensation data. So the bottom line here is that equal pay and EEOC reporting data, as this issue makes clear, is political. It changes from presidency to presidency. And so what's happened because of the political wrangling is that states are stepping up, and where the federal pay act isn't necessarily remedying some of these disparities, states are attempting to do so. And in this year alone, you'll see that we've got 11 states that have implemented laws in an attempt to remedy the Pay Act. We're going to look for just a moment at Massachusetts, where we here at HRW reside. And part of why we bring this one up is that it's particularly broad, but it's also emblematic of many of these laws that have recently gone into effect, containing salary history bans, basically something for you to look at in your handbooks. Sometimes we see this. Employers are prohibiting employees from discussing their salaries with each other, and in Massachusetts you can't do that anymore. Also, when interviewing employees in Massachusetts, you cannot ask them anything about their past pay history. And there are only in Massachusetts 6 justifications for pay disparity. Notably, we don't have that catch-all that the Federal Equal Pay Act has for any other reason that would justify the disparity. In Massachusetts, it's much more specific. If you don't fall into one of the categories, you are not in compliance with the law. So the takeaway here for you as an employer is to, of course, first check the laws in your state. Perhaps you're in one of those 11 states this year that implemented this new Equal Pay Act laws, and you'll need to see what that requires of you. In Massachusetts, you're incentivized to do a pay audit. If you are, in fact, ever sued by an employee for failure to pay equally, you can assert this as an affirmative defense. And you also would want to consider using a lawyer if you do an audit, because the information that you collect and synthesize may be able to be retained under privilege versus being required to produce in a lawsuit. So taking a look at your current pay system, looking at any disparities, and then asking yourself, are there legitimate non-discriminatory explanations for these disparities? If the answer is no, what corrective actions do you need to take, and how do you go about doing that? And doing it for the one person, again, might impact other employees in the organization. So it's really a holistic review by you as an employer. So So that's our quick and dirty on things to think about on this particular topic.
So in California and other states, in the golf industry, you've got a superintendent, which tends to be paid much higher than maybe a food and beverage person. But when you look at their duties as far as the number of employees they supervise and the impact on a club, the argument, at least in California, can be made that they are very equal, and so the pay should be equal. It's a quandary for the clubs, since the superintendents tend to be very much highly compensated compared to food and beverage. So it's something where you definitely need to consult with your attorneys to make sure you have a good justification for pay differentials, especially in the different job titles that have traditionally been maybe occupied by female versus male.
Mike, that's a great point, and it kind of highlights a takeaway item for employers. I mean, what can you do to sort of get ahead of or keep on top of the wave of this scrutiny? And I think, one of the things you can do is, if you have two job classifications that you really feel are different, that are different, that the industry knows are different, but if you took them out of context and somebody could say, well, I think they're comparable. I mean, if you've got an equal pay law like we do in Massachusetts and apparently like you guys do in California, it's not equal work, it's comparable work. And so the argument is open, which two positions are comparable? Well, if they really are different and you know they're different, maybe it's time to update your job descriptions and make sure those job descriptions accurately reflect all the differences. Now, what matters is what people are actually doing. The job description is not going to save the day if it's not accurate. But if that's one piece of evidence that should exist and that you have some control over, that can really flag and highlight the differences that you see in these positions and that you want the world to see if you're ever called upon to defend it.
Okay, so Title VII. Title VII of the Civil Rights Act of 1964 is a federal statute that prohibits employment discrimination on the basis of several categories, including race, sex, color, national origin, and religion. In the past, this has been expanded to include other things, and in 2020, it may be expanded again to include two new protected classes, which would be sexual orientation and gender identity. So the question of whether or not the Supreme Court will expand Title VII comes from three separate cases separated into two categories. So the first category, sexual orientation, comes from two cases where two gay men were fired from their jobs after their employers found out that they were gay. That's the Second Circuit case and the 11th Circuit case. The third case, which deals with gender identity, comes from the facts where the plaintiff was a director at a funeral home for 7 years. She originally presented as a man, but then expressed her desire to dress as a woman as she underwent her transition from male to female, and she was terminated shortly thereafter. All three individuals filed suit, and in 2020, the Supreme Court will decide whether or not Title VII protects them. So what is at stake for employers? For employers who live in states where there are no state laws protecting individuals based on sexual orientation or gender identity, the decision in 2020 from the Supreme Court could make extreme changes as far as employment handbooks and policies, especially including things such as someone's dress code. So basically, Title VII is, since the federal law, it's a floor and not a ceiling. So for states that don't already have a protection, you would have to be aware of the changes that would come forward from the federal decision. And we have a map that gives a brief overview of states that currently have protections, states that have limited protections, and states that have none. So for the states that have no current protections, that's where you need to be extremely aware of what happens with these three cases.
Thank you. And I'm guessing that a lot of people on the call, are in jurisdictions that already have these protections. We keep talking about California, Massachusetts, New York. There's a lot of places where these Supreme Court cases are sort of of academic interest because these protections already exist, and certainly bigger chain organizations with multi-state operations might have a unified anti-discrimination policy that covers some of these protected classes, even if the law hasn't quite caught up yet. But if you're looking at trends in 2020, that one is certainly going a certain direction. And if we had to predict which way the Supreme Court is going, what would we predict?
Oh.
It's a tough one. It's a tough one.
I don't think they're going to go there.
Yeah, you got one vote for no. So we'll see what happens. Like I said, in Massachusetts, it's academic. We already have the protections here. We have had for a long time, and we have a certain, we feel a certain way about it. But it'll be interesting to see what the Supreme Court says. All right, transitioning to what I call MeToo / retaliation. So, if we're doing crystal ball gazing and trying to figure out, if I was going to get sued as an employer in 2020, what would the most likely cause of action be? For my money, I think the odds on favor would probably be wage and hour, which Mike Derderian is going to talk about. That's really become the big gorilla in terms of claims to be on the lookout for. But only slightly behind is this category I want to talk about next. So let's go to the polling question. In 2018, the most frequently alleged basis of discrimination in charges filed with the EEOC was gender discrimination. True or false? So I'll lead in by saying about 76,000 claims were filed nationally at the Equal Employment Opportunity Commission in fiscal year 2018, and the EEOC released its data. And you can see the answer to this question is actually false. The Me Too movement aside, retaliation claims are the big gorilla. So if we're talking about things to look out for in 2020, the wage and hour stuff has been for years and will continue to be a big third rail item to look out for. But retaliation claims have been on the rise and have already arrived in that regard for years. And they were last year, according to the EEOC data, they comprised 52% of all claims filed. So why is that? What's going on with retaliation claims? Certainly it's been the fastest growing area of discrimination charges that have filed, not only at the federal level, but we see it at the state level as well. I think one of the reasons is because it's easier to win. There were a series of Supreme Court cases maybe 10 years ago that really made it easier for, as a legal analytic matter, for plaintiffs to bring and win these claims. But also, I think it's just human nature. I think, if you're accusing somebody of something like being a racist, a sexist, something of a base level of discrimination, it's tough for a jury or a judge or a commission to get their minds around. There's almost a skepticism there, and you have to really show me. But if you're accusing somebody like a supervisor of retaliation, if your whole claim is, look, that supervisor was really mean to me after I complained about him to HR, I just think that's a level of human nature that people can get their minds around. They're just easier claims to win. So both the legal analytics have gotten easier to win. I think the human aspect of it is easier to get your mind around, and so we're seeing it. We're seeing the uptick in these cases, and that will continue. Next slide, I guess. So, what does it take to bring a retaliation claim? These are the basics, sort of the prima facie case. An employee has to have engaged in protected activity, which could be complaining to HR, could be complaining to the EEOC, but it doesn't have to be at that level. It could be just raising a concern of discrimination. The employer obviously has to know about that. Number two, an adverse employment action would have had to have occurred to the employee. Something bad happened. Could be fired, could be written up, but it doesn't have to be that severe. Like I said, the Supreme Court cases have lowered the standard. It's easier to prove. You don't need to say, I was fired, I got demoted. Something, quantifiably bad happened to me in the workplace in order to bring a claim. And then number four, there's got to be some sort of causal connection. And usually it starts with timing. If I make a protected complaint on Monday and something bad happens to me on Tuesday or Friday or the next week or the next month, if there's a sufficient link in timing, that's often gotten you more than halfway home to meeting that initial causal connection. So I guess I would finish with this before we move on to hostile environment harassment. What can employers do to avoid retaliation claims? A lot of it is common sense things we already know. It's not rocket science, but obviously we should have robust anti-discrimination and anti-retaliation policies. We probably already do have those. Training of supervisors, making sure people know timing is indeed everything. Doesn't mean you change your course of action, but maybe it means that you document things better and make sure that we can defend personnel actions, especially at the supervisory level. That's where the action is happening, and that's where the liability is created. And consistency, obviously. It's tough for someone to claim that they're the victim of being picked on, of being retaliated against, if they're being treated really the same as everybody else along the way. So that's just a quick and dirty on retaliation. The reason it's on the list is because it really has been a big fraction of claims that we see, and it continues and is getting bigger. On to sort of the sexual harassment, the Me Too front of this stuff. A lot of what's in the news is a certain type of sexual harassment. If you took all the big cases that have really been front and center for the last couple of years, the Harvey Weinsteins, the Matt Lauers, that's a certain type of harassment. Actually, it's a much rarer form of harassment. It's what's called the quid pro quo form of harassment. It's when a supervisor, when the boss who has power over an individual abuses that power. Far more frequent is the hostile environment claim. And so I wanted to say a few words about that. This should be familiar to people at this point. Not much has really changed in this regard, but it's worth talking about because these claims are on the rise. There's an increased awareness to this stuff, and we need to make sure that our managers, our supervisors, the folks that need to know, understand this stuff. There's the standard. You can see it. It's unwelcome sexual conduct, pictures, words. It's supposed to be a pretty high standard. When you read it and take it in a vacuum, to meet that level, it's supposed to be something that really interferes with your work, creates an intimidating, humiliating, or hostile, offensive work environment. I think that standard, as a practical matter, has been eroded in recent years. It takes less and less these days to sort of meet that standard to get a claim, and we're seeing that, particularly as a younger generation enters the workforce. I think their expectations, rightfully so, are of a certain level of professionalism in the workplace that may be different than our older workers are frankly accustomed to. So there's a training and a retraining component of this that goes on. Next slide, just to keep moving. So when do you know when something crosses the line? In a sense, for the folks on this call, it doesn't matter. If there's inappropriate conduct, we address it. We don't need to know that it's illegal inappropriate conduct. But if you wanted to play lawyer for a day, or judge, this is what one would look at to see if something really does cross the line from being merely inappropriate to being illegal. And these are some of the key elements. One is the conduct has to be unwelcome. We know that. It's part of the definition, but that's almost neither here nor there. If somebody's complaining that conduct, sexualized behavior, say, is unwelcome, then almost by definition it is. The severity and pervasiveness, that's the second bullet. That's the one I want to focus on for a minute. This is what we look at. This is what a anti-discrimination commission would look at. This is what the lawyers, the judges would look at. If you're trying to gauge conduct in the workplace and say, is it illegal sexual harassment, or is it just something I need to pretty quickly take care of? That's what you're looking at, whether it's severe or pervasive. There's an inverse relationship. If something is very pervasive and happens a lot, well, it doesn't have to be that severe. Like a joke, bad, sort of a toxic work environment created by everybody just having lewd comments and behavior. Any individual instance of it is not severe, but it's pervasive. And the flip side of that is if something is very severe but not so pervasive, one time may be enough. A touching, that's very, very severe. It doesn't happen to happen more than once to really have a problem from a sexual harassment front. And that's basically it in the analysis. It's got to be unwelcome, severe, or pervasive, and it's obviously got to have some relationship to protected class status. In this case, we're talking about sex. What do we do when we have a problem? Everybody, nothing new on this front, but as I say, these claims will continue to be seen in 2020, so it's a good reminder of what our obligations are. If we, as an employer or in the HR world, are made aware of a problem, we have to take prompt and effective remedial action. That's all we can do. Prompt and effective doesn't mean somebody gets fired every time. It's just got to be effective. Doesn't mean the complaining party, the alleged victim, gets to choose their remedy, but we have to do something that's effective to stop the offending behavior. Why is this a big deal? Well, because the damages in this area continues to be substantial when you are found to have committed a violation. Back pay, potential front pay, emotional distress, attorney's fees, punitive damages. So it's the usual list that is a fearsome list, and that helps ensure that we all make sure we do the right thing. So we just wanted to flag retaliation and sexual harassment as they will continue to be hot items, I think, in 2020. And with that, we'll move on to another one in wage and hour.
Hey, this is Mike. Let me just throw something out real quick, and maybe you can help the audience. They're not only dealing with employees, supervisors, but what about the members? Certainly, as you addressed, there's a gap between in the ages. Maybe the younger worker has a higher expectation of professionalism than the older member who looks at the country club as his guys club.
Thank you, Mike. We talked about this. I said, basically, give me a kick, an audio kick if I forget to bring this up. So thank you for reminding me. Yeah. So, like any employer, the obligation is to provide a workplace that's free from harassment. And that workplace can be affected by outside parties, in this case, members. So the long and the short of it is, if the problem is being created by a member or members, that doesn't get us off the hook, because it's a problem that is in the workplace and that affects the workers. They have the same phenomenon in law firms in theory, right? I mean, if, oh my God, the firm's biggest client is really causing problems to the poor, often young female at the front desk, and it would not be appropriate to say, well, listen, have a thick skin about it because that's the firm's biggest client. No, that's not an appropriate response, and it's not appropriate to say, well, listen, the customer's always right, the member's always right, or that's just Bob. I know him, he's a good guy. No, so I think in this day and age, more and more so than ever, that legal obligation, which has always been there, is really going to be taken very, very, very seriously. So if a problem in the workplace is created by an environment created by members, we got to deal with it the exact same way as if it were created by a supervisor. So that's my 2 cents on that, Mike.
And in California, we have a law now that any employer has more than 5 employees has to have training for all employees, not just supervisors. A little bit of a delay in the mandate because the state couldn't come up with the training they're supposed to provide, but a best practice for all employers to consider, whether it's mandated or not, is to do the training. There's quite a bit of materials out there. Certainly your law firm is well equipped to do a training if that's the route you wanted to go. But there is definitely some video training out there that's available too. And it's just to creating that awareness, definitely within the club, to have the board of directors, general manager, make sure that it's a clear statement that everyone knows that it is not acceptable and that the club will stand behind the employee if, in fact, they need to report something.
Yeah, my little list of sort of what can I do to avoid minimize claims, one of them is training. I mean, you got to have a policy, you got to have a culture that's conducive to the right environment. But training is required in a lot of states now. New York just passed training requirements, and New York, in fact, they put out a video that you could use to do the sexual harassment training. But at the state level, they've said, but that has to be supplemented with interactivity. So I'm not a big believer in video trainings. I think there has to be interactivity, and I just think it's one of those things that. It's like an inoculation. You do the training, everybody's kind of nodding their head, but you make it fun, you make it interactive. People aren't hearing anything new, but it's like an inoculation. It keeps people on their best behavior for a certain period of time. And then if you got a culture that slips back into old ways, you do the training again. If you do trainings once a year, that's what the laws in a lot of these states that require training want you to do. And I am a big believer, and I really do think that as long as you don't wag your finger at people and you make it fun and interactive, people do learn something and they appreciate it, and the behavior does improve, even though redoing it every year is important too. All right, we better move on to wage and hour. So Mike Derderian is getting closer to the microphone here.
All right, hey everybody. So I'm going to briefly touch upon wage and hour issues because, as Pete said, it's it's prevalent in this area, and I'm going to specifically spend a little time on the independent contractor laws, particularly because there's some interesting sort of independent contractor questions that come up in the club environment. For years there's been an intense focus on wage and hour issues. It's really been a boon for plaintiffs' lawyers. And the violation of calling an employee an independent a person an independent contractor versus an employee, it results in a wage and hour violation, and the consequences of misclassifying an employee our potential unpaid overtime, taxes, unemployment insurance, multiple damages. So it's definitely something clubs need to stay focused on. So let's go over a brief overview of sort of what wage and hour, what the issue is. So the source of law, we have both federal and state law. The federal law, as we all should or probably do know, is the Fair Labor Standards Act. That act sets, among other things, the minimum wage requirement and the overtime requirements. Many states also have wage and hour laws. I put the Massachusetts law up here, but I'm sure whatever individual state you are might have some different peculiarities with respect to wage and hour issues, so definitely check that out. And like I said, this is this area is such a big deal because it's easy to for a plaintiff's lawyer to sort of find some type of technical violation of the law, and once that can be established, these claims balloon pretty quickly. You have usually these claims are brought sort of in a class action posture. The statutes call for multiple damages. There's attorney's fees provisions, and also a lot of insurance, policies don't cover it. So that's why it's such sort of a serious topic we need to pay attention to. And I've listed some of the common pitfalls here. Off the clock work, misclassification issues, which we're going to talk about briefly in a second. I won't go through them all, but errors in paying out vacation, tip issues, which is certainly something clubs probably deal with. So I would definitely stay on top of all these little pitfalls and make sure you don't get caught up. All right, so we're going to turn to a discussion about independent contractors. So there's two tests. Go to the next slide here. So we have, this is kind of the federal test, the federal law. It's sort of a multi-factor test. The IRS has its own 14-factor test, and this test, kind of focuses in on sort of the nature and the degree of control of the principal. How much is the employer kind of directing that worker, telling that worker when to show up, what to do, what to wear, etc. And then you can sort of see all the other factors that also play into the analysis. And then, a number of states have also passed their own laws, and the states' laws, we can just go to the next slide, are even more strict. And so sort of listed some of the states that kind of go with the federal control and direction test. And you see also states that have a more stricter test, which commonly referred to the ABC test. So the ABC test, and I'll just use Massachusetts as an example. In Massachusetts, a person is presumed to be an employee unless the employer can establish all three prongs of the test. Prong one, the work is done without the direction and control of the employer. That sounds a lot like the federal test, right? We're going to look at the direction and control of what the employer's relationship is to the employee. And you just jumping down to the third prong, the work is done by someone who has their own independent business or trade. Okay, that's a factor in the federal test too. But we should really focus in on prong two, which a lot of these ABC tests have, prong B. And it asks, is the work performed outside the usual course of the employer's business? And that's really the prong that gets a lot of these employers caught up. Because, a worker might have control over his or her work. They might be, in some type of trade or industry that, commonly kind of works within independent contract, the contractor status. But if they're doing work that's sort of integral to what the company's doing and could be described as, inside the usual course of business, it's going to be a problem in a lot of these states. So I figure would take an example here. This is a sort of a real life example. I was part of a trial, and Captain Phillips was not on trial. Just you can let your breath out. Captain Phillips was not in the courtroom, but the trial centered around a scallop fishing boat captain. And one of the principal questions of the trial was the boat captain an independent contractor or an employee? And if you go through this federal test, you go through the state test, geez, it really looked like the captain was an independent contractor. The captain, kind of works once a year, chooses what boat and what company he or she wants to work on. They take a huge profit, of the number of fish and the number of sales that come from the catch. They're in complete control, of the boat and of people who are on the boat. As the captain, actually nobody can give him any directions, according to admiralty law. And so all these factors, he was 1099 by the company. So all these factors kind of pointed to him being an independent contractor. But on the other hand, what was the usual course of business of this fishing, company? It was to go out and catch fish, and that's what a captain does. So it was a really close question. In this case, the jury found that the captain was an independent contractor, but really a toss-up. Sort of gets to the crux of kind of this whole issue is a lot of these examples can be very close. So, you know, in the club example, at least the golf club example, hopefully you all recognize this picture from the movie Caddyshack. You know, I think his name is Noonan. It was the caddy. Is he a independent contractor, or, you know, is he an employee? And again, it's probably a close question. I did some digging around, and, you know, recently I have seen and read about a lot of clubs being sued based on caddies being misclassified. I saw a headline published just yesterday, you know, quote unquote, America's snootiest golf club stiffs caddies. So, you know, class action was filed just yesterday in New York federal court against National Golf Links in Long Island. So, you know, the allegations of these lawsuits are that, you know, caddies are at the direction and control of the caddy master in the club. You know, they're being told when to show up, how to dress, how to perform their job, you know, how to speak to the client, which is the golf member. And obviously, it seems like being a caddy could be within the usual course of business of what a golf club does. You know, similar suits have been filed in other states. A lot of these suits seem to settle. You know, I would look to your particular state's law. In Massachusetts, the legislature has specifically exempted caddies from being employees. So at least we're covered in Massachusetts. But you know, golf caddies, you know, positions like, you know, golf or tennis instructors, you know, these all present sort of close questions, and there's sort of the discussion to be had about the risk the club wants to take and how they classify people. And certainly, you know, the local and the state laws play a huge role. Does that ABC test apply? Are you in one of the states with a stricter test? Or is it just kind of the loose federal test where maybe you could slip by a little bit? So these are all important issues to, you know, they have been important issues over the past 2 years, and, you know, looking forward to 2020. Again, just yesterday, huge lawsuit being filed against one of the, you know, snootiest golf clubs, quote unquote, in New York. You know, I would definitely pay attention with this and seek advice and counsel if you think you have an issue.
Thanks. And the one thing I would say, I mean, we get this phone call sort of a lot where somebody has a question: is this employee misclassified, or am I doing this right, or should they be a exempt or non-exempt? And if the answer is, well, you might be doing it wrong, oftentimes the client will say, but everybody does it this way. And so that is not a defense, and it comes up all the time. And I think plaintiffs' attorneys almost take advantage of that. I mean, there's like people are asleep at the switch a little bit, and I get the sense that this industry, you know, has historically done things a certain way, and our job is to sort of, you know, shine a light on this stuff and reinforce what folks in this call probably already sense, which is, you know, there's some danger areas in some of the ways the industry has classified people, and there's not it will not be a protection to say, but everybody does it this way. So a fresh look is a good idea. All right. So,
and just know the risks are a lot higher nowadays, because maybe you have a 401k for your employees, and independent contractor didn't get to participate in that. Microsoft lost on that years ago. ACA, if you haven't offered the ACA and you haven't reported those independent contractors' employees and they're retroactively determined to be employees, now you've got ACA violations. So the risk is just exponential compared to what it used to be. So it is worth the conversation to make sure your general manager, your board understands there's a huge risk for going with tradition versus what the law is today.
Yep. So we are getting close to the end here. So I said we wanted to cover labor issues. We put one slide on the deck just to be able to expand or contract as needed, because we want to leave some time for questions. So I'll try and say a few words about labor issues and what 2020 might bring, or what we're starting to see, and then we'll open it up for questions. But on the labor front, so there's not that many unionized clubs, because there's not that many unionized private sector employers. There's only about 6 or 7% these days. But even so, the National Labor Relations Board, the NLRB, has really gotten into the act in recent years in the non-union workplace. And so this is something to keep an eye on. Just yesterday, I literally saw 2 decisions or pronouncements from the NLRB that affect the non-union workforce. So I don't know if you guys caught these, but it was literally just in the last 24 hours, the NLRB came out with something for everybody on this call. And these days, if you follow this stuff, the NLRB is a very political agency, and they swing with the political winds of the presidency. So the current NLRB, the board in Washington, D.C., is 3-2 Republican. And so the policies are basically undoing what was done in the Obama administration. But just yesterday, they came out and changed their mind as to what they had said a few years earlier under the Obama administration, and now said, look, if employers, if you're conducting, say, a sexual harassment investigation, it's okay to instruct the witnesses, your employees, not to talk about the matter while the investigation is pending. You guys might not even have known about this. This one's kind of a little sleeper issue that's been out there for years since the Obama administration, that up until 2 days ago, the advice would have been, look, if you're conducting an investigation, you really can't be telling employees not to talk about it, because they have a labor right, a Section 7 labor right under the labor laws to be able to talk with their coworkers about working conditions, which includes your investigation. Well, so the NLRB just sort of reversed itself yesterday on that. Another issue they reversed themselves yesterday on was reversing a case that was called Purple Communications. Don't know if you've seen this one, but back in 2014, again in the Obama administration era, the rule changed and said if you allow your employees to use email, you have to let them engage in protected activity, which could be union organizing, which could be complaining about the employer, which could be, all sorts of stuff you wouldn't want people sending mass emails about on your system. But that's what the law said in 2014. And just yesterday they said, no, what? Forget we said that. Email is like your company equipment, just like the copy machine. You can limit it to business use only. So if you were looking through your handbook, which is where I'm going with all this, every year almost it seems you got to kind of go through your handbook and review it, because the labor board seems to be taking these wild swings on what types of policies are legal or illegal in the non-union sector. And this was one of them that's been changing recently, on whether your email system can have that sort of policy that says only for business use. Other policies about maintaining confidential information. We've got a policy at the club that says, hey, listen, employees, you must protect the confidential information of this club and of members. A couple of years ago, the NLRB would have said that's illegal. Now there's more leniency. So the point I just wanted to make on this is it's always a good annual thing to do to update your handbook. And one of the things that keeps changing is the labor board's view of your employment rules. Good news is it's changing favorably. So if you haven't had your handbook reviewed in a little while, you might have a little more leeway to have some more reasonableness reinserted. But I wanted to at least flag that as something to look for in 2020. The Labor Department is very active. Under the Trump board, it's sort of pro-employer. With that, we'll pipe down and open it up for questions for a few minutes at least.
Okay, and we've got quite a few, so here we go. The first question is, can you discuss how to qualify or pay a fluctuating work week employee?
Boy, okay. Yes. Okay, so for the folks who haven't heard of this one, the fluctuating work week method of calculating overtime. It's approved under the federal system, but you got to look at your state to make sure it's approved under the state system. It actually is here in Massachusetts. It's edgy. I wonder one of these days whether somebody's going to say, boy, you can't do that. Let me tell you how edgy it is. They used to call it Chinese overtime. They don't call it that anymore. It's disfavored. But it goes, we could spend 10 minutes explaining it, but it kind of goes like this. You basically pay a non-exempt person by a salary. And that salary covers all their hours of work. So if they work 40 hours a week, they get the same salary. If they get 50 hours a week, they get the same salary. 60, the same salary. And the only overtime you would pay is halftime, right? Instead of time and a half, you're saying, well, they've already got one of it. Now they only need to get the half because their salary covered the one of it. So the more they work, the lower their rate is, which is why it's edgy. But it's lawful, but it's supposed to be meant for employees whose hours really do fluctuate, not somebody who's got a fixed schedule. So, I always cringe when I hear it. And a lot of my clients, when I talk about this option, say, I don't think we're going to do that because sooner or later that's going to be a little too edgy. But right now, in the appropriate circumstance, it's technically legal under the federal law, maybe legal under the state law. We'd really have to talk about it, live to really, make sure it was appropriate.
Right. Can you flip to the contact slide that's after this one? There, and then we need to remember, so if you want to take a quick look at your screen, And I'll put it in the follow-up email too, but if you want to email somebody to continue that discussion, you could do that. And then maybe flip back to the credits, the SHRM credits slide, so that people can see that. Okay, next question. Do you know if Washington is allowing any percentage of salaries to be commissions or bonuses? I heard that it did not, so it is very different than the federal law.
Oh, if Washington,
Washington State.
Oh, okay. I thought it was federal.
Yeah.
Yeah, because the Department of Labor changes do have a component of that, but boy, I have no idea in Washington State.
Yeah, nor do I.
Yeah, I apologize.
Okay.
If they want to email me, I can send them information on it. We have a resource state by state. This is Mike from Paychecks.
Okay, is that mwales@paychecks.com?
Yes.
WALES and Paychecks, PAYCHEX. Okay. Next question. Are there any FLSA exempt categories that could include golf or tennis professionals?
So, nothing that's directly on point. The traditional white-collar ones are administrative, executive, unless the golf pro supervising two people, right? I mean, that one could fit in. Boy, it seems like a tough fit to go under administrative, exercising independent judgment over matters of significance, and doing non-manual work. These pros are doing a lot of manual work as part of their job. So there's not a specific exemption that I'm aware of for the golf pro.
No.
Yeah. I'm trying to think what would be the easiest fit. Boy, if it's really a fit, you might get inside sales, I suppose, if you really, were had it set up a certain way. But I don't know.
The other thing I can do is after the fact, I can share the list of questions with the contact information. So if there's something you want to follow up on, you'll be able to get to the person that asked it directly.
Perfect.
Come up with something else. So here's the next one. We have a director of instruction that is paid less than $34,000 annually, but receives all lesson income and totals over $50,000. He does not supervise anyone. Will we need to look at reclassifying him in 2020?
Yes, you will. He meets the salary, and he is paid. What is he paid weekly? I assume he's paid over 485. 455 and will meet the 684 number, but he's not supervising anyone, and he has to supervise 2 or more employees and have right to fire, hire, and weigh in on management of employees. And it does not sound like, at least from what the question poses, that is the case here.
So say that again. You said there's almost a combined compensation up to $50,000. How is the compensation?
Sorry, he's paid less than $34,000 annually, but receives all lesson income and totals over $50,000.
Lesson income.
Lesson income.
Yeah. So the salary level's not even there. So it doesn't sound like that's a good. And you know what? My litmus test always, by the way, to me, I mean, there's nothing in the law that says their level of salary over the minimum threshold matters, unless you get to the highly compensated. But when you got somebody who's close to the line like that, and I'm never comfortable with it anyway. So there's a lot of. It'd be tough to give this one a clean bill of health. Again, we can talk offline, but what I'm hearing is the salary is going to be below the threshold. The duties we got an issue with. Yeah, you can hear from the reaction on our end. We're kind of frowning over here.
Okay, so next one. It's my understanding that as a private club, we are not required to report any of our data to the EEO, pay or otherwise. Can you please comment?
So, when we planned the seminar, we sort of said, we're not going to get into we're employment lawyers. We're not going to get into are we private clubs or places of public accommodation, that kind of stuff. And this kind of, to me, walks into that area. Short answer is I don't know the answer to that. And I know it's a very interesting dynamic issue of whether a club is truly a private club. And a lot depends. We went to law school for 3 years to learn that the answer is always it depends. So I think that's a longer conversation. I do know outside the realm of the EEO, the reporting, that there's been a lot of private clubs that have been surprised to find that they're not viewed that way by the federal government. They host weddings there. They They have, member for a day kind of stuff, and suddenly they advertise on the web, and suddenly they're seen conveniently as a place of public accommodation. I wonder if it's the same analysis for the EEO. I don't know, but again, offline would be a good one to dig in deeper on that.
This is Mike. I would just say if you have the right software, the EEO1 report is pretty simple to do. You're populating the information, your EEO reporting season, if you will. You're going to ask the employees the questions, or you're going to fill in the information for them, press a button, send the report off. Might be better just to do it.
Well, this is Kathleen. I will add that that's an interesting point. If you do submit an EEO1, we have had these issues with respect to collection of the pay data as well. So, employers that don't have to report, I know, are happy not to report. I wouldn't necessarily volunteer, but we just don't know whether there's the requirement or not. So I completely hear where you're coming from, Mike.
I'd say we're batting about 500 on these questions. Let's see if we can get one more in that we can nail.
Okay. Do tennis and golf pros fall under the professional category for exempt status? Additionally, is lesson income treated like commissions?
So professional, no. I mean, professional exemption, there's two types. There's the creative and there's the other one.
Creative and learned professional.
Yeah. They're not going to fall into the learned category. That's for
lawyers and doctors.
Yeah. Maybe engineers and they're not going to fall into the creative artist ones either. So they're just not going to make it under that exemption.
Okay. Was there more to that? I've got one more, and then we would have gotten through all the questions. Okay. Can you elaborate on weighted overtime requirements for EEs with multiple pay rates? For example, golf pro teaching lessons and hourly employee. Any other reasons?
All right. We're gonna end on a good note. We got this one too, I think. So just to make sure everybody understands the questions, you got a non-exempt employee that works at different rates. And when it comes time to calculate overtime, how do you do it? So the law says, and this is the federal law, but this is going to be the same in any state to this extent, that you pay somebody overtime based on their regular rate. And I think sometimes the mistake is made that people just pay somebody based on the rate they happen to be working when they hit that 41st hour. And that's not right. The way the law wants you to do it is to have a weighted average. So if you've worked 35 hours at X rate and you've worked 15 hours at Y rate, you add the total compensation up and divide it by the number of hours. In that case, it's 50, and you get the regular rate, and it's going to be somewhere between those two rates the person was paid. And that's the regular rate you use to pay the overtime. One caveat is the federal law allows something which I know in Massachusetts we don't allow. So again, some of this stuff becomes state specific, but what the federal law says is, yeah, if you want to avoid all that though, the employer and the employee can agree that they're, for convenience, that the extra rate will be at the rate at which the overtime hours are worked. So you can do exactly what I said we can't do here if you do it by agreement with the employee. But Massachusetts overtime rules do not recognize that, and so we can't do it that way here. You got to do the weighted average. So it's more complicated to say it than it sounds. I mean, it's pretty simple math, but just be aware. If you got somebody with two rates, you're probably going to want to pay them overtime at a weighted average of the rates. And it's just really a matter of adding up all the compensation and dividing it by the hours and then figuring out the overtime with that calculation.
I want to just touch, you just said all compensation, so at least here in California, and I'm not sure if it's federal or not, is if you have a golf pro earning commission or bonuses that are in a regular basis, so they would be, and they're hourly employees, whether it be a golf pro or anybody else, then those wages also have to be calculated into your weighted overtime rate.
Great point. Yep.
And really, if you have the right technology, if you're using a golf management software, there's certainly many of them out there. I don't know the ins and outs of them, but that's what many clubs use for time and attendance, or you're using a time and attendance system. That's where that calculation should be done. It will be pretty simple for a club to do it because you don't have that many pieces of other compensation, unlike other industries. So again, it's just having the right technology and having it set up properly so that you're allowing the system to do it for you and keep you out of trouble. And it may be a very random time. where you have employees working in two rates. Maybe it's only when you are having, like someone mentioned, outside wedding, where if they're working an outside banquet function, the server's getting a higher rate of pay than if they're working in the dining room.
Sounds good.
All right, well, that's it for questions. Again, I would just like to say thank you to HRW Law Firm and Mike Wales for all of the information that was shared today. The contact information is on the screen, and Mike Wales' email is mwales, MWALES, @paychex.com. Thank you, everyone, for joining us.
Thank you.
Thank you.
Thank you.